Before we dive in, please remember, this presentation is for informational and educational purposes only. It is not legal advice and does not create an attorney-client relationship. The rules and customs discussed can vary significantly by jurisdiction, court, and even by individual judge. Always consult your local rules and experienced local counsel. A young lawyer, brilliant, top of his class, stands before the judge in his first major trial. The stakes are sky high. He's prepared for every legal argument, every possible objection. He approaches the bench to hand the judge a crucial piece of evidence. He extends his hand, and the judge recoils. A cold silence falls over the courtroom. The jury shifts uncomfortably. The opposing counsel smirks. What did he do wrong? He used his left hand. In that particular judge's courtroom, that was a sign of profound disrespect. The case wasn't lost in that exact moment, but the lawyer's credibility was shattered. He lost the judge, and soon after, he lost the case. All because of a rule he never learned in a textbook. That story, or a version of it, plays out in courtrooms across America every single day. We spend hundreds of thousands of dollars on law school to learn the substance of the law, torts, contracts, civil procedure. We spend months studying for the bar exam, memorizing exceptions to exceptions. But what they don't teach you, what can't be found in a casebook, is that the courtroom is a theater. It's a stage governed by a secret language of tradition, ritual, and unwritten rules. And mastering this performance, this courtroom etiquette, isn't just about looking good. It is a weapon. It's the silent killer of legal careers, or the invisible engine of their success. Breaking these rules can get your evidence excluded, your argument ignored, and your client a one-way ticket to a guilty verdict. So, in this presentation, we are pulling back the curtain. We're going to break down the most critical rules of courtroom etiquette that every single lawyer in the United States must follow to not just survive, but to command respect and win. This isn't fluff. This is the practical, hard-won knowledge that separates the amateurs from the artists. The entire ecosystem of the courtroom revolves around one central figure, the judge. Your relationship with that judge, from the moment you step into their courtroom, is the single most important factor in your case, second only to the facts themselves. Therefore, the first and most foundational rule of all courtroom etiquette is demonstrating unwavering, profound respect for the robe. This isn't about liking the judge personally. It's about respecting the institution they represent. They are the ultimate authority, the director of the play, and the final arbiter of your client's fate. You show this respect in three key ways: how you speak, how you move, and how you ask for permission. Let's start with how you speak. There is only one way to address a judge in a United States courtroom. It is Your Honor. Not Judge. Not Judge Smith. Never ever sir or ma'am. Using sir or ma'am might seem respectful in any other context, but in a courtroom, it's a critical error. It makes you sound like a layman, a tourist in a professional's world. More importantly, it personalizes the interaction. You are not addressing John or Jane Smith, the person. You are addressing the living embodiment of the judicial branch of government. Your Honor is a direct address to the office, to the honor of the court itself. It signals that you understand the gravity of the proceedings and your place within them. Think about the psychological impact. When you say, "Judge, my argument is," it sounds like you're having a casual debate, puts you on an almost equal footing. But when you say, "Your Honor, the defense's position is," you are framing your argument as a humble submission to a higher authority for their consideration. It is deferential, respectful, and paradoxically far more persuasive. I once saw an out-of-state lawyer, clearly very smart, repeatedly call a notoriously strict federal judge judge. After the third time, the judge put down his pen, leaned forward, and said in a voice that could freeze fire, "Counselor, in my courtroom there is only one judge, and he is in the Bible. I am Your Honor. Please do not forget it again." That lawyer's face went white. He never recovered his momentum. His credibility with the judge was gone. Next is how you move. Your body language must scream respect. The most fundamental physical act of deference in a courtroom is rising. You stand whenever the judge enters the courtroom. You stand whenever the judge exits the courtroom. You remain standing until the judge is seated or gives you permission to be seated. This isn't just an old-fashioned tradition. It's a universal sign of respect for authority. It's the civilian equivalent of a military salute. But it doesn't stop there. Every single time you address the court, you stand. Every single time. Whether you are making an objection, responding to a question from the bench, or beginning your opening statement, you get on your feet. Standing when you speak forces you to project your voice. It conveys seriousness, and it physically places you in a position of supplication before the bench. It's a nonverbal cue to everyone in the room, the judge, the jury, the opposing counsel, that what you are about to say is important and worthy of the court's attention. Sitting while addressing the judge is the courtroom equivalent of mumbling in a job interview. It projects laziness, disrespect, and a fundamental misunderstanding of the environment you're in. Even if the judge says, "Counselor, you may remain seated," a savvy lawyer will often reply, "Thank you, Your Honor, but I'm more comfortable standing," or will simply stand anyway for brief objections. It shows energy and a deep ingrained respect for the process. Finally, let's talk about the 5 most powerful words in a lawyer's courtroom vocabulary. May it please the court. This phrase is not just a flowery opening to a statement. It is a strategic tool of immense power. At its core, it is a request for permission to speak. It acknowledges the judge's absolute control over their courtroom. You are a guest in their house, and you speak only when given the floor. Starting any substantive argument, whether it's an opening statement, a closing argument, or a complex legal motion, with "May it please the court" is non-negotiable. It sets a tone of deference and professionalism that immediately puts the judge at ease. But its utility goes far beyond that. It's a way to gracefully interrupt. Imagine opposing counsel is saying something you believe is misleading the jury. Instead of jumping up and shouting objection, he's lying, which makes you look emotional and out of control. You stand calmly and wait for a pause. Then you address the judge. "Your Honor, may I be heard?" You've shown respect, you've maintained your composure, and you've put the ball in the judge's court. It's also your shield. If a judge asks you a difficult question you're not prepared for, you can buy yourself a precious few seconds to think by starting your response with a deliberate, "May it please the court, the answer to your Honor's question is." It's a verbal tick that signals respect while your brain catches up. These 3 elements, addressing the judge as "Your Honor," standing when you speak to the court, and using phrases like "May it please the court," are not just arbitrary rules. They are the bedrock of courtroom advocacy. They are the signals you send, consciously or not, that you are a professional who understands and respects the gravity of the law. Mastering this foundation doesn't guarantee you'll win, but ignoring it almost certainly guarantees you'll lose the respect of the one person whose opinion matters most. But respecting the judge is just the price of admission. The real, complex dance of etiquette happens when you turn your attention to the other players in the room. And the most dangerous and delicate relationship you must manage is with the one person you are paid to defeat, discredit, and dismantle: your opposing counsel. The rules for engaging with them are a masterclass in professional paradox, where you must fight with fierce civility and extend courtesies, even as you're trying to destroy their case. And that is where most new lawyers make their biggest and most damaging mistakes. The most common mistake is forgetting that your opposing counsel is not your enemy. They are your adversary, and that is a critically different thing. An enemy is someone you seek to destroy, to vanquish utterly. An adversary is a professional opponent in a structured contest, bound by the same rules you are. Confusing the two is a fatal flaw, because it leads to the single most destructive behavior a young lawyer can exhibit: taking it personally. The moment a case becomes personal, you lose. You lose objectivity, you lose perspective, and most importantly, you lose the respect of the court. I once saw a brilliant young attorney, top of her class, absolutely shred a witness on the stand. It was a masterclass in cross-examination. But then, during a recess, she cornered the opposing counsel in the hallway. She was still riding the high of her courtroom victory, and she said something along the lines of, "Did you see your guy squirm? He's going down, and you're going with him." What she didn't see was the judge, walking out of his chambers just down the hall, who heard every single word. The temperature in that courtroom dropped 20 degrees for the rest of the trial. Every objection she made was met with a cold stare. Every request was scrutinized. She hadn't broken a law, but she had shattered the unwritten code. She had shown the judge that she was driven by ego and animosity, not by a pursuit of justice. She revealed her character, and the judge found it wanting. Her client's very strong case suddenly became an uphill battle, all because she couldn't resist a moment of gloating. This brings us to the first cardinal rule of dealing with opposing counsel: maintain a firewall between the professional and the personal. Your job is to attack the merits of their case, not their character, their intelligence, or their integrity. You will be tempted. Oh, you will be tempted. You'll receive a motion from them that misstates the law so badly you'll wonder if they bought their degree online. You'll get an email at 10 p.m. on a Friday that is so passive-aggressive it could be taught in a psychology class. In those moments, you must breathe. You must remember that your response is not just for them. It's for the record. It's for the judge who might one day read that email chain when deciding a discovery dispute. Your response should always be professional, detached, and focused exclusively on the legal and factual issues. Never reply in anger. Draft the scathing email if you must, get all the venom out of your system. Then delete it. And write the one you will actually send. Counsel, thank you for your email. I respectfully disagree with your characterization of the facts. Our position remains as stated in our brief dated May 15th. I am available to discuss this further at your convenience. That's it. You've given them nothing. No emotional reaction to feed on, no unprofessional language they can use against you later. You've just professionally and firmly held your ground. This isn't about being a doormat. It's about being a stone wall. Unflappable, immovable, professional. This leads directly to the second rule. Get it in writing. The legal profession runs on paper trails. A phone call can be a great way to quickly resolve a simple scheduling issue, but for anything of substance, anything that could remotely be disputed later, follow it up with an email. This is called a confirming email, and it is your best friend. Let's say you have a phone call with opposing counsel, Mark, to discuss extending a deadline. You both agree to a new date. The call ends, you feel great. You're cooperating. 2 weeks later, the original deadline passes and Mark files a motion to compel, claiming you failed to produce your documents on time. You're dragged in front of the judge, sputtering, But we had an agreement. I spoke to him on the phone. The judge will look at you with a mixture of pity and annoyance and ask, do you have anything in writing, counsel? And when you say no, your credibility will be shot. You'll look disorganized, naive, and frankly, a little foolish. Now imagine the same scenario. You have the phone call with Mark. You hang up and immediately type out a one-sentence email. Mark, this email is to confirm our telephonic conversation 5 minutes ago, during which we agreed to extend the deadline for plaintiff's document production to June 30th. If this does not accurately reflect our agreement, please let me know immediately. You hit send. Now the ball is in his court. If he doesn't respond, his silence is his consent. If he tries to pull the same stunt, you walk into court, hand the judge a copy of that email, and you become the hero of the story. You are the organized, diligent professional who was wronged by a sneaky adversary. In 2 minutes, you've protected your client, your case, and your reputation. Never ever underestimate the power of a simple confirming email. It has saved more legal careers than the bar exam. The third and perhaps most nuanced rule in dealing with your adversary is to know when to fight and when to agree. New lawyers eager to prove their toughness often fall into the trap of fighting over everything. They object to every discovery request. They refuse to grant even the most reasonable extension. They treat every single issue as a battle in a larger war. This is exhausting, inefficient, and it makes you look like an amateur to the judge. Seasoned lawyers understand the power of the stipulation. A stipulation is simply a formal agreement between the parties on some matter. It could be as simple as stipulating that certain documents are authentic, so you don't have to waste time in trial bringing in a witness to say, yes, I recognize this invoice. Or it could be as complex as stipulating to a whole series of undisputed facts to narrow the issues for trial. Why would you ever agree with the other side? Because it shows the judge you are a reasonable, rational officer of the court. You are not wasting the court's valuable time bickering over things that don't matter. You are focused on the core dispute. Granting a reasonable request for a 1-week extension on a non-critical deadline costs you nothing, but it builds goodwill. That goodwill might pay off dividends later when you're the one in a jam and need an extension yourself. More strategically, stipulating to non-essential facts allows you to control the narrative. By agreeing on the 99 things that don't matter, you can focus all of the jury's attention and all of your firepower on the one thing that does. You are clearing the underbrush so everyone can see the one tree you want them to focus on. I remember a massive construction defect case. Hundreds of thousands of documents. Dozens of witnesses. The young lawyers on the other side wanted to fight over every single email, every blueprint, every change order. Our lead partner, a veteran of countless trials, sat them down. He said, look, we can spend the next 6 months and $100,000 of our client's money fighting about whether this email from 2018 is authentic, or we can agree that all documents produced by either side are authentic, subject to relevance objections, and we can get to the real issue, why this foundation cracked. By proposing this sweeping stipulation, he did 3 things. First, he saved both clients a fortune. Second, he instantly looked like the most reasonable person in the room to the judge. Third, and most brilliantly, he forced the other side to focus on the weakest part of their case, the cracked foundation, which was exactly where he wanted the fight to be. He gave away nothing of value to gain a massive strategic advantage. That is the true art of dealing with opposing counsel. It's a delicate dance of courtesy, documentation, and strategic concession. You are firm, but you are fair. You are a zealous advocate for your client, but you are a professional colleague to your adversary. Mastering this balance isn't just about good manners. It's about effective, winning advocacy. It's about understanding that the person on the other side of the V is not your roadblock. They are part of the path to resolution. And how you navigate that path with integrity and strategic foresight will define your career long after the details of any single case have faded. But your reputation, for good or for ill, will be etched in stone. And the single most powerful chisel that carves that reputation, the one that can build you into a monument or grind you down to dust, belongs to the person sitting elevated before you, draped in black. We're talking, of course, about the judge. Your relationship with the court, your ability to navigate the complex currents of judicial temperament and authority, is not a soft skill. It is the bedrock of effective advocacy. Get it wrong, and the merits of your case, no matter how strong, will be lost in a sea of your own making. Let's begin with the most fundamental, non-negotiable rule. It's so simple, yet you would be stunned how many new lawyers, flush with confidence from a mock trial win, get it disastrously wrong. You will stand when you speak to the court, and you will address the judge as Your Honor, not Judge, not Judge Smith, and under no circumstances, Sir or Ma'am. This isn't about stroking an ego. It's about acknowledging the gravity of the institution. When you say Your Honor, you are not just speaking to the man or woman in the robe. You are speaking to the office they hold. You are addressing the full weight and authority of the judicial system itself. It's a verbal signal that you understand the rules of this sacred space, that you are a professional operating within its confines. I once saw a hotshot lawyer from out of state, brilliant on paper, repeatedly call a seasoned old-school federal judge. The first time, the judge's eyebrow twitched. The second time, a vein in his temple started to pulse. The third time, the judge put down his pen, leaned into his microphone, and said in a voice that could freeze fire, "Counselor, in my courtroom, there are 2 types of people who call me judge. The other lawyers and my wife. You are neither. You will address me as Your Honor, or you will be addressing me from the hallway. Do we have an understanding?" The lawyer turned beet red. His credibility, his entire posture crumbled in that instant. He lost the room. More importantly, he lost the judge before he'd even finished his first sentence. Don't be that lawyer. Your Honor. Burn it into your brain. This deference extends to your physical presence. You stand when the judge enters. You stand when the judge leaves. You stand when you address the court. Why? Because it is a physical manifestation of respect. It is a nonverbal cue that you are rising to the occasion, that you are formally engaging in the serious business of the court. Sitting and speaking to a judge is the equivalent of showing up to a black tie gala in flip-flops. It communicates a lazy contempt for the proceedings. It tells the judge, the jury, and everyone else that you don't take this seriously. And if you don't take it seriously, why should they take you seriously? Now let's talk about what happens when the judge speaks to you. The rule here is even simpler, but infinitely harder to follow in the heat of battle. You shut up and you listen. You never ever, under any circumstances, interrupt a judge. I don't care if the judge is misstating a fact from your brief. I don't care if they are asking a question based on a complete misunderstanding of your argument. You let them finish. The instinct, the desperate, clawing urge of every advocate, is to jump in, to correct, to clarify, to stop the train before it goes off the rails. You must kill that instinct, because when you interrupt a judge, you are screaming 3 things at them. 1. What you are saying is not important. 2. What I have to say is more important. And 3. I am not listening to you. I am just waiting for my turn to talk. It is the ultimate act of professional disrespect. Instead, you let them finish their thought or their question completely. You take a breath. That pause is not weakness. That pause is power. It shows you are calm, you are in control, and you are giving their words the respect and consideration they deserve. Then and only then you respond. You can begin with a phrase like, "I appreciate the court's question, Your Honor, and if I may clarify one point," or "Thank you, Your Honor. The critical fact that I believe addresses the court's concern is," you are not challenging them. You are assisting them. You are a helpful guide, not an impatient adversary. The difference in perception is colossal. This leads to the most sophisticated skill in judicial communication: learning the difference between arguing with a judge and making your record. A rookie lawyer hears a ruling they disagree with, and they start to argue. "But Your Honor, that's not fair." "But Your Honor, the case law clearly states." They are trying to win the argument in the moment. This is a fool's errand. You will never win an argument with a judge in their own courtroom. It's like trying to win a swimming race against a shark in the ocean. The environment is built for their victory. A veteran lawyer understands this. When a judge makes a ruling that is adverse to their client, they don't argue. They pivot. Their goal is no longer to persuade this judge right now. Their goal is to perfectly preserve the issue for a higher court, the Court of Appeals. This is called making your record. Sounds like this. The judge says, "I'm sustaining the objection." The witness will not answer that question. The rookie argues. The pro says calmly and clearly, "Noted for the record, Your Honor. For purposes of appeal, my proffer is that the witness would have testified that he saw the defendant hiding the evidence, which goes to the issue of consciousness of guilt. I object to the court's ruling on the grounds that it is a statement against interest and vital for my client's defense." Do you see the difference? There was no "but Your Honor." There was no whining. It was a clean professional statement. He identified the issue, he stated what the evidence would have been, the proffer, and he stated the legal basis for his objection. It's all there in the transcript, waiting for the appellate court to read. He has done his job. He has protected his client's rights for the next stage of the fight. He has shown the trial judge respect while simultaneously laying the groundwork to have that judge's ruling overturned. That is the chess match, not checkers. Arguing with the judge is checkers, a quick, brutish, and losing game. Making your record is chess, thinking several moves ahead to an ultimate victory. Finally, and this may be the hardest rule of all to stomach, you must learn to lose with grace. The judge will rule against you. Often. On small things and on big things. And when a judge rules against you after you've made your record, the correct and only response is two simple words. "Thank you, Your Honor." It feels insane, doesn't it? Thanking someone for denying your motion, for excluding your key piece of evidence, for essentially kneecapping your case. But it is a move of profound psychological power. It communicates to the judge that you respect their authority and the finality of their decision, even if you disagree with it. It communicates to the jury that you are a professional, unfazed by setbacks. It communicates to your opponent that you are not rattled. You are in control. It ends the discussion and allows you to move on to the next battle without carrying the stench of defeat with you. A lawyer who whines or sulks after a bad ruling looks weak. A lawyer who says a crisp, "Thank you, Your Honor," and immediately moves on looks formidable. They look like someone who has a plan B. Someone who is always prepared. These are not just quaint traditions. They are the essential tools of courtroom control. How you speak to the judge, how you stand, how you listen, and how you disagree, these actions create an aura around you. An aura of competence, of respect, of quiet confidence. It is this aura that makes a judge want to listen to you, that makes a jury trust you, and that builds that reputation we spoke of, the one that will be etched in stone. It is a reputation not just for being a zealous advocate, but for being a true officer of the court. So, how is that reputation built moment by moment in the crucible of the courtroom? It begins with the very first rule, the bedrock upon which all other courtroom conduct rests: your interaction with the judge. The judge is not merely a referee. They are the living embodiment of the law in that room. They are the sovereign of that domain, and your respect for the position must be absolute and unwavering. This starts with something so simple, so fundamental, that it's often taken for granted until it's broken. You always stand when you address the court. You stand when the judge enters the room, you stand when they leave, and you stand every single time you speak to them. This isn't some archaic tradition clung to for the sake of pageantry. It is a physical act of deference. It is a nonverbal signal that you understand the gravity of the proceedings and recognize the authority of the bench. When you rise, you are not just rising for the man or woman in the robe. You are rising for the institution of justice they represent. It's a small act that carries immense symbolic weight. Failing to do so is like shouting your disrespect through a megaphone. It's an unforced error from which it is very difficult to recover. And when you speak, there is only one acceptable form of address. Your Honor. Not judge, not sir, not ma'am. It is always Your Honor. I once saw a young, very bright attorney from out of state refer to a famously strict federal judge as judge. The temperature in the room dropped 20 degrees. The judge slowly removed his glasses, polished them with a cloth and said, "Counselor, in my courtroom, you will either address me as Your Honor, or you will not address me at all. Is that understood?" The lawyer, pale as a ghost, stammered an apology, but the damage was done. For the rest of the hearing, he was climbing a mountain of judicial skepticism that he had built for himself with a single word. Your Honor is a key that unlocks the judge's ear. It shows you know the rules of the house. It's a password that signals you belong. The corollary to this is even more critical. You never, under any circumstances, interrupt the judge. When the judge is speaking, you are listening. You are a statue. You are a sponge absorbing every word, every nuance, every inflection. You wait until they have finished their sentence, until you can hear the period at the end of their thought, before you even think about opening your mouth. Interrupting the judge is not just rude. It's strategically idiotic. First, it tells the judge you value what you have to say more than what they have to say, a fatal miscalculation. Second, you miss the opportunity to understand what is actually on the judge's mind. Often, if you just let them finish, they will reveal their primary concern, their point of confusion, or the very question you need to answer to win your motion. Interrupting is like slapping away a helping hand. Patience is your ally. Let the judge speak, listen intently, and then, and only then, you rise and respond. This web of respect, however, doesn't end at the bench. It extends horizontally to your opponent, the opposing counsel. This is where many lawyers, especially young ones, get it wrong. They believe that being a zealous advocate means being a pugnacious, disagreeable, and obstructionist jerk to the person on the other side of the aisle. This could not be further from the truth. The courtroom is a theater of conflict. Yes, but the lawyers are not the combatants. Their arguments are. Your opposing counsel is not your enemy. They are your professional colleague, engaged in the same difficult, stressful work as you are. Treating them with professional courtesy is not a sign of weakness. It is a sign of profound confidence and long-term strategic thinking. The legal community, even in a big city, is surprisingly small. The lawyer you're fighting against today might be the lawyer you need a favor from tomorrow. They might be your co-counsel on a massive case 5 years from now. A decade from now, they might be the one wearing the black robe, looking down at you from the bench. Burning a bridge with unprofessional behavior is an act of career self-sabotage. This means you never engage in personal attacks. You attack the argument, not the advocate. You challenge the evidence, not the integrity of the person presenting it. The difference is monumental. It's the difference between saying, "Your Honor, my learned friend's interpretation of this statute is flawed for 3 specific reasons," and saying, "Your Honor, my opponent is either deliberately misleading the court or he hasn't bothered to read the law." The first is advocacy. The second is an insult that poisons the well. It makes the judge's job harder, it creates unnecessary animosity, and it signals to everyone in the room that your case is probably weak, so you've resorted to throwing mud. Professional courtesy also manifests in small practical ways that pay huge dividends. Granting a reasonable request for an extension on a deadline. Stipulating to facts that are not in dispute to save time and money. Picking up the phone to resolve a discovery issue instead of firing off a nasty email and filing a motion. These actions do more than just make the litigation process more civil. They build a reputation for you as a reasonable, trustworthy professional. Judges appreciate this more than you can imagine. They are drowning in cases, and lawyers who can work together to narrow the issues are a godsend. When you are the lawyer who makes the judge's life easier, you are the lawyer the judge wants to listen to. You gain credibility that can't be bought. A currency that becomes invaluable when you have a close call and need the judge to give you the benefit of the doubt. But the circle of respect extends even further, into an area many lawyers foolishly ignore: the court staff. The court clerk, the bailiff, the court reporter. These are not peripheral players. They are the gears and levers that make the entire judicial machine function. Disrespecting them is not just bad form, it is tactical suicide. The court clerk is the gatekeeper of the judge's world. They manage the docket, they process your filings, they are the conduit for all communication with the chambers. Being rude or demanding with the clerk is like insulting the person who holds the only key to the building you need to enter. Conversely, being polite, patient, and respectful can make your life infinitely easier. A friendly clerk might call you to warn you of a procedural defect in your filing before it gets rejected, saving you from a missed deadline. They might help you navigate a confusing local rule, or find a convenient time for a hearing. They wield immense practical power. Treat them like the professionals they are. The same goes for the bailiff or court security. They are in charge of order and safety. They are the judge's eyes and ears in the gallery. Show them courtesy. A simple good morning and a respectful demeanor go a long way. And the court reporter, the silent figure typing away, is perhaps the most important person in the room for your future. They are creating the official record. Everything they type is the ground truth of what happened in that proceeding. If you have to appeal, that transcript is your Bible. Speak clearly, avoid talking over others, and be respectful of their requests to slow down or repeat something. Helping them create a clean record is helping your future self. I remember a case where a lawyer was desperately trying to get an emergency hearing. He was arrogant and dismissive to the clerk on the phone. The clerk, following the rules to the letter, told him the judge's next available slot was in 3 weeks. The opposing counsel called a few minutes later, was polite, explained the same urgency with courtesy, and mentioned he'd be happy to work around whatever was easiest for the court. The clerk found a cancellation on the judge's calendar for the very next morning. That is the hidden power of courtroom etiquette. It's not just about pleasing the judge. It's about recognizing that the courthouse is an ecosystem. Every interaction, from the judge on the bench to the clerk at the counter, contributes to your reputation and, ultimately, to your effectiveness as an advocate. Your respect must be a 360-degree phenomenon. It's a quiet, consistent demonstration that you understand and honor the entire process of justice. Now, this idea of 360-degree respect solidifies the moment you pass through the courthouse doors. Think of the courtroom not as a room, but as a theater of justice. It is a purpose-built stage where every word, every gesture, and every silence is amplified and scrutinized. In this theater, there is a script. It's not written down in a single book, but it is known by every seasoned actor on that stage. And mastering this unwritten script is the difference between a commanding performance and a career-ending flop. Let's begin with the most fundamental element of this script: the language. The words you use in a courtroom are not just words. They are instruments of deference, precision, and strategy. The most common phrase you will ever utter is "Your Honor." But have you ever stopped to think about what it truly means? You are not just addressing the person in the robe, you are addressing the office they hold. You are acknowledging the weight of the institution, the power of the state vested in that single individual to alter the course of human lives. Saying "Your Honor" is a constant, verbal bow to the rule of law itself. Using "sir" or "ma'am" might seem polite in the outside world, but in the courtroom, it's a subtle demotion. It's like calling a 4-star general buddy. It shows you don't understand the hierarchy, the very structure of the world you've stepped into. Then there's that classic, almost cinematic opening. "May it please the court." A rookie lawyer might think this is a question, that they are asking for permission to speak. They are not. It is a statement of hope, a formality that sets the tone for everything that follows. It's the equivalent of a musician tuning their instrument before a symphony begins. It signals to the judge and everyone present, "I am ready, I am respectful, and I am about to proceed in a manner befitting this institution." Omitting it or stumbling over it is like an actor walking on stage and immediately tripping over the furniture. It makes the audience, in this case the judge and jury, instantly question your competence. This specialized language extends to how you address your adversary. You will hear lawyers refer to each other as "my learned friend" or "counsel for the plaintiff." This isn't some quaint, outdated pleasantry. It is a powerful strategic tool. By referring to your opponent with respect, you elevate the entire proceeding. You are signaling to the judge that this is a battle of ideas and legal principles, not a personal squabble in a schoolyard. It subtly tells the jury, "We are both professionals engaged in a serious search for the truth. Now let me show you why my interpretation of that truth is the correct one." Conversely, referring to your opponent as him, her, or simply by their last name, especially with a sneer, does the opposite. Cheapens your argument. It makes you look petty and emotional, and if a jury thinks you're driven by personal animosity, they'll start to suspect your facts are too. I remember a young, brilliant but arrogant attorney in a complex commercial litigation case. He was sharp, no doubt about it, but he consistently referred to the senior opposing counsel, a man with 30 years of experience, as Johnson. Just Johnson. Not Mr. Johnson. Not counsel. After the third or fourth time, the judge, a quiet but formidable woman, peered over her glasses and said, "Counsel, in this courtroom, we refer to our colleagues with the appropriate professional courtesy. I trust one will not have to remind you of that again." The air in the room went cold. In that single sentence, the judge didn't just correct his language, she shattered his credibility. The jury saw him not as a confident maverick, but as a disrespectful upstart who had to be disciplined like a child. His brilliant arguments were suddenly tainted by his amateurish demeanor. He lost the case, and I'm convinced that moment was the turning point. This brings us to the second, equally critical rule: your silent testimony. Your body language in a courtroom is a constant broadcast to the judge and jury, and you better be in control of the message. The moment the judge enters the room, you rise. You don't slouch back down. You stand with purpose until the judge is seated. When the judge leaves, you rise again and remain standing until they are gone. This isn't about subservience. It's about marking the beginning and end of a formal, sacred process. It's the ringing of the bell that signals the start of a round. Your posture at the counsel table speaks volumes. Leaning back in your chair, arms crossed, suggests disinterest or arrogance. Frantically shuffling papers suggests disorganization. Slouching over the lectern as if you need it for physical support projects weakness. The ideal is a state of controlled, focused energy. You should appear calm, alert, and ready. Your hands should be visible, used for deliberate gestures, not for fidgeting with a pen, adjusting your tie, or, heaven forbid, checking your watch. Every nonverbal tick is a distraction that pulls focus from the most important thing in the room, your argument. But the most unforgivable sin of body language is the reactive display. The eye roll when opposing counsel scores a point. The loud, theatrical sigh when a witness gives an answer you don't like. The smug grin you flash to your client when you think you've cornered someone in a lie. These are not just unprofessional. They are a form of contempt for the process. You are, in effect, trying to testify without being sworn in. You are attempting to influence the jury with your personal opinion, your emotion, rather than with evidence. A good judge will shut this down immediately. A great trial lawyer maintains a poker face worthy of a world champion. Their expression should betray nothing but calm, professional concentration. Whether they are winning a critical point or having their entire case dismantled before their eyes, their demeanor should remain steady. This communicates immense strength and control to a jury. It tells them that you are the anchor in a sea of confusing facts and emotional testimony, the one person they can rely on to be rational and objective. This leads directly to our third rule, which governs the very act of speaking. Master the rhythm of interruption and silence. The number one unbreakable commandment is this: thou shalt not interrupt the judge. Ever. When the judge speaks, you stop. You stop mid-word. You stop mid-syllable. You stop mid-breath. You close your mouth and you listen. The judge is the conductor of the orchestra. To interrupt them is to try and grab the baton from their hand. It is a direct challenge to their authority, and it is a challenge you will lose 100% of the time. The judge controls the flow, the pace, and the procedure of the trial. Your job is to work within that framework, not to fight against it. The rule about interrupting opposing counsel is slightly more nuanced. You can't simply talk over them when you disagree. That creates a chaotic record and makes you look like a bully. The proper way to interrupt is with a formal objection. Objection, Your Honor, hearsay. It's a clean, precise surgical strike, not a clumsy brawl. You state the objection, you state the legal basis, and then you fall silent and wait for the judge's ruling. You do not argue with the other lawyer about it. This is called speaking objections, and it is forbidden. Your audience for an objection is the judge, and only the judge. I once saw a promising case go down in flames on appeal because of this. It was a personal injury trial, and the two lawyers despised each other. Every testimony was a barrage of interruptions, shouting matches, and snide remarks. The court reporter's transcript was almost useless. It was filled with notations like crosstalk and both counsel speaking simultaneously. The plaintiff won a huge verdict, but the defendant appealed. The appellate court, trying to decipher the record, found it so hopelessly muddled that they couldn't determine if key evidence had been properly admitted. They had no choice but to reverse the verdict and order a new trial, all because two lawyers couldn't control their impulse to speak out of turn. The client had their life-changing victory snatched away. Not by the law, not by the facts, but by a catastrophic failure of basic courtroom etiquette. Every word you speak in that room is for the record. Speaking clearly, calmly, and one at a time isn't just about being polite. It's about building a clean, solid foundation upon which a victory can stand and an appeal can be defended. Your language, your posture, and your respect for the rhythm of the court. These aren't the soft skills of law. They are the bedrock of effective advocacy. And at the center of that bedrock, sitting elevated above everyone else, is the single most important person in the room, the judge. Think of the judge not as a referee, but as the god of this small universe. They control the time, the tone, the evidence, and the very air you breathe. Disrespecting them, even unintentionally, is the fastest way to lose a case before you've even made your argument. The first, most fundamental rule is how you address this deity. It is Your Honor, not judge, not sir or ma'am, and absolutely under no circumstances by their last name. Your Honor. It's not a quaint tradition. It's a verbal signal that you understand and respect the authority of the office they hold. You are not speaking to a person named Jane Smith. You are addressing the bench, the embodiment of the law in that room. I once watched a young, brilliant, but arrogant attorney from a big city firm try a case in a small rural court. He kept referring to the seasoned old-school judge as Judge Thompson, thinking it sounded familiar and confident. After the third time, Judge Thompson slowly took off his glasses, set them on the bench, and leaned into his microphone. The entire courtroom went silent. He said, "Counselor, my friends call me Bill. My children call me Dad. The lawyers who wish to continue practicing in my courtroom call me Your Honor. Which one are you going to be?" The color drained from the young lawyer's face. He lost every ounce of credibility in that one moment, not because of a legal misstep, but because of a failure of respect. From then on, every ruling seemed to go against him. Coincidence? Maybe. But he had poisoned the well. This deference extends to your physical presence. Unless the judge explicitly tells you otherwise, you stand when you speak to them. When the judge enters or leaves the room, you stand. It is a physical manifestation of respect, a nonverbal Your Honor. It shows everyone, especially the jury, that you take these proceedings seriously. And then there's the cardinal sin. Never, ever interrupt the judge. When the judge is speaking, you are listening. You are a statue. You are a recording device. You are anything but a source of sound. Interrupting the judge sends a clear message. My thoughts are more important than yours. It is a direct challenge to their authority, and it is a challenge you will lose 100% of the time. If the judge is making a point you disagree with, or misunderstanding your argument, you wait. You let them finish completely. Take a note. Then when they are done, you may say, "Your Honor, if I may, I'd like to clarify a point," or "Thank you, Your Honor. For the record, I would respectfully disagree for the following reasons." You are not arguing with them. You are assisting the court in preserving the issue for a potential appeal. This leads directly to the art of the objection. An objection is, by its nature, an interruption of the proceedings. But it is a sanctioned and necessary one. The key is to do it with surgical precision. You don't shout. You don't wave your arms. You stand up, project your voice clearly, and state the legal basis for your objection. Objection, Your Honor. Hearsay. Objection. Leading the witness. And then you stop talking. This is where so many new lawyers get it wrong. They want to launch into a full-blown argument explaining why it's hearsay. Don't. The judge is a lawyer too. They know the rules of evidence. State the objection, and wait for the judge's ruling or for them to ask for your argument. If the judge says sustained, your job is done. The improper question is dead. If the judge says overruled, your job is also done. You have preserved the issue for the record. You say, "Thank you, Your Honor," and you sit down. Arguing with the judge after they've ruled, what's known as arguing balls and strikes, is professional suicide. It shows you don't respect their final say, and it can earn you a swift contempt charge. But while the judge holds the gavel, the ultimate power over your client's fate often rests in the hands of 12 ordinary people sitting in a box to the side. The jury. They are the audience you must persuade, the human element in a system of cold, hard rules. And your interaction with them is governed by a completely different, but equally rigid set of etiquette. The number one rule of jury trials? You are always on stage. From the moment you walk into the courthouse until the moment you get in your car to go home, you are being watched. Jurors see you in the hallway. They see you in the cafeteria. They see how you interact with your client, your co-counsel, and most importantly, the court staff. I knew a lawyer who was a master performer in front of the jury, charming, eloquent, and respectful. But during a recess, he thought no one was looking and made a dismissive, eye-rolling gesture to his co-counsel after the opposing lawyer, a much younger woman, made a point. A juror, heading to the restroom, saw the whole thing from the corner of her eye. She later said that single moment of condescension made her distrust everything he said. He wasn't just arguing his case, he was a bully. His client lost. Your character is on trial just as much as the facts. Every sigh, every smirk, every whispered comment is part of the evidence the jury uses to decide if they can trust you. When you do address the jury during opening statements, witness examinations, and closing arguments, you must speak their language. This isn't about dumbing down your case. It's about translation. The jury doesn't want a law school lecture on tortious interference or the nuances of the Fourth Amendment. They want a story. They want to understand what happened in human terms. Instead of saying the defendant's actions constitute a breach of the implied warranty of merchantability, you say, the company sold him a ladder that they promised was safe, but it was cracked, and it broke the first time he used it. You are a storyteller, a translator of complex legal concepts into fundamental ideas of right and wrong, fairness and responsibility. And there is one sacred, unbreakable rule when it comes to the jury: the forbidden zone. You are to have absolutely no contact with a juror outside of the official courtroom proceedings. None. If you see a juror at a coffee shop, you turn around and leave. If you end up next to one in an elevator, you stare at the doors and don't say a word. A simple good morning can be misconstrued as an attempt to curry favor. A conversation can lead to an immediate mistrial, throwing away weeks or months of work, and potentially leading to sanctions against you. The wall between you and the jury must be absolute to ensure the integrity of the verdict. You've addressed the judge, you've connected with the jury, but there's one other crucial relationship in that room, one that can make your job a pleasure or a living hell: your relationship with opposing counsel. Television and movies have created this myth that to be a great lawyer, you must be a venomous shark who despises the person at the other table. The reality is the exact opposite. Civility is not weakness. It is a strategic advantage. You and your opponent are professional adversaries, not mortal enemies. The person you're fighting against today might be the person you need a favor from tomorrow. An extension on a deadline, a simple stipulation to avoid calling a needless witness. The legal community, even in a big city, is surprisingly small. Your reputation follows you everywhere. If you become known as the lawyer who is needlessly difficult, who makes personal attacks, who lies or misleads, that reputation will stick to you like tar. Judges will hear about it. Other lawyers will refuse to grant you any professional courtesy. They won't trust your word on anything, forcing every single minor issue to be a drawn-out, formal battle. You will spend all your time and your client's money fighting procedural skirmishes instead of focusing on the merits of your case. Contrast that with the lawyer who is a zealous advocate for their client, but treats their opponent with professional respect. They are tough but fair. They don't make it personal. They keep their word. This lawyer finds that the doors of cooperation are open to them. They can resolve discovery disputes with a phone call instead of a motion. They can agree on facts not in dispute, a stipulation, to save the court's time and focus the jury on what really matters. This not only makes their own life easier, but it makes them look reasonable and confident in front of the judge. The judge sees two professionals working to find the truth, not two children squabbling in a sandbox. Being a good steward of the court's time is one of the most effective ways to earn a judge's respect. And remember, your opponent is just doing their job the same as you. They have a client to represent and a duty to advocate for them. Respect the role, even if you vehemently disagree with their position. The greatest trial lawyers in history could tear each other's arguments to shreds in court, and then go share a drink afterward, because they understood the difference between the case and the person. That professional detachment is the mark of a true master of the craft. And this mastery extends beyond just your opponent. It extends to the very room you're standing in. The courtroom isn't just a room. It's a theater of justice, and every single person in it has a role to play. But the director, the one who holds absolute authority, sits on a raised platform behind the bench. This brings us to one of the most fundamental, non-negotiable pillars of courtroom etiquette: how you interact with the judge. You do not address the judge by their name. Not Mr. Smith. Not Judge Smith. You address the judge as Your Honor. This isn't a suggestion, it's a commandment. The term Your Honor is a linguistic tool of profound importance. It's a constant verbal reminder to everyone in the room, including the lawyers, the jury, and even the judge themselves, that the proceedings are not about the personal opinions of the man or woman wearing the robe. They are about the authority of the law that the judge represents. You're not speaking to a person, you're speaking to the bench. You're addressing the embodiment of the judicial system. When you say Your Honor, you are honoring the law itself. This deference is also physical. Every lawyer knows the ritual. When the judge enters the room, you rise. When the judge leaves the room, you rise. You stand when you speak to the court, and you remain standing until the judge gives you permission to be seated. This isn't an archaic tradition for tradition's sake. It's a physical act of respect. It signals to everyone, especially the jury, that you recognize and submit to the authority that governs the entire process. It says, I understand the rules of this space, and I am here to operate within them. Failing to observe this is professional suicide. I once saw a young, brilliant but arrogant attorney from a big city firm try a case in a small rural county. He thought the local customs were quaint and beneath him. He would lean on the lectern when addressing the judge, use a casual tone, and once even referred to the judge as judge without the Your Honor. The judge, a man who had presided over that court for 30 years, let it slide for about an hour. Then, in the middle of the young lawyer's opening statement, he held up a hand. The courtroom went silent. The judge leaned into his microphone and said, Counselor, in my courtroom, we stand up straight when we speak, and we address the bench as Your Honor. This is not a coffee shop. Consider this your only warning. The young lawyer turned beet red. His credibility, his entire posture of a hotshot city lawyer, evaporated in that single moment. The jury saw him get dressed down like a schoolboy, and from that point on, they viewed him not as a confident advocate, but as an outsider who didn't respect their world. He lost the case, and I'm convinced it was lost in that exact moment of disrespect. Your relationship with the judge sets the tone for your entire case. It's not about being a sycophant. It's about demonstrating that you are a serious professional who respects the gravity of the proceedings. A judge who feels respected is a judge who will listen. A judge who feels disrespected will be looking for every reason to rule against you. This respect for process extends from the judge to the very evidence you present. Introducing an exhibit in court is not like showing a friend a photo on your phone. It is a meticulous, formalized dance with specific steps that must be followed perfectly. First, you ask the judge for permission to approach the witness. Your Honor, may I approach? Once granted, you approach the court reporter. Please mark this as Plaintiff's Exhibit 1 for identification. The reporter tags the document. Then you turn to your opponent. I'm showing opposing counsel what's been marked as Plaintiff's Exhibit 1. You hand them a copy. You allow them time to review it. Only then do you approach the witness. I'm showing you what's been marked as Plaintiff's Exhibit 1 for identification. Do you recognize it? Every single one of these steps is critical. Why? Because this ritual ensures fairness and creates an unassailable record. Showing it to the court reporter ensures it's officially part of the proceeding. Showing it to opposing counsel prevents trial by ambush, where you surprise them with evidence they've never seen, giving them no chance to prepare a response. The entire system is designed to bring the truth to light, not to see who can pull the cleverest trick. A lawyer who tries to skip these steps, who just waves a document in front of a witness or the jury, will be shut down so fast their head will spin. The judge will strike the evidence, instruct the jury to disregard it, and admonish the lawyer in front of everyone. It signals that you are either incompetent and don't know the rules, or you're a cheat who is actively trying to break them. Neither perception will win you any favors. Think of it like a surgeon in an operating room. Every instrument is accounted for, every procedure is followed in a precise order, because a single misstep can be disastrous. In court, the integrity of the evidence is paramount. The formal dance of introducing it protects that integrity. Now, we've talked about respecting the judge and respecting the process of evidence. But what about the heat of the moment during witness testimony, when the verbal battle is at its peak? This is where the rules of engagement are most critical, and where Hollywood gets it the most wrong. The number one unbreakable rule is you do not, under any circumstances, interrupt the judge. When the judge is speaking, you are silent. You are a statue. You don't talk over them, you don't finish their sentences, you don't even think about it. The judge is the ultimate arbiter of the courtroom. Interrupting them is like challenging the referee's call in a football game. It will only get you penalized. The one time you are allowed and in fact required to interrupt is to object. But an objection is not a moment for dramatic speeches. It's a surgical strike. When opposing counsel asks an improper question, you must act instantly, before the witness can answer. You stand. You state the basis for your objection in as few words as possible. Objection hearsay. Objection relevance. Objection leading the witness. That's it. You are not making an argument. You are flagging a violation of the rules of evidence for the judge. The judge will then rule. Sustained, meaning they agree with you and the witness can't answer. Or overruled, meaning they disagree and the witness can answer. And here is the moment that separates the professionals from the amateurs. If the judge overrules your objection, the conversation is over. You sit down. You move on. What you absolutely do not do is argue with the judge. You don't say, "But Your Honor, it's clearly hearsay," because the moment you start arguing with the judge's ruling, you are in contempt of court. You have crossed the line from advocacy to insubordination. The judge has made their decision. Your job is to accept it and continue trying your case. The purpose of the objection was to make the judge aware of the issue and to preserve that issue for a potential appeal later. By objecting, you've done your job. Arguing after the ruling does nothing but destroy your rapport with the court and signal to the jury that you're a sore loser who doesn't respect authority. I've seen lawyers get so caught up in the injustice of a single ruling that they poison the well for the rest of the trial. The jury sees them as combative and disrespectful, not to the opposing lawyer, but to the judge, the one neutral party in the room. And if you lose the jury's respect, you have already lost your case, no matter what the evidence says. True courtroom mastery is knowing not just when to speak, but more importantly, when to be quiet. And this principle of quiet professionalism extends far beyond your interactions with the judge and jury. It fundamentally defines the most misunderstood relationship in the entire legal universe: your relationship with opposing counsel. Hollywood and television have sold us a lie. They've painted a picture of the courtroom as a gladiator pit where lawyers are mortal enemies, trading venomous insults and engaging in personal vendettas. They show lawyers who despise each other, who see the person across the aisle not as a professional adversary, but as the villain in their own story. And let me tell you, any lawyer who brings that attitude into a real courtroom is committing career suicide. They are the amateur, the novice, the one who is about to be taught a very painful lesson by a true professional. The biggest mistake a trial lawyer can make is to make the fight personal. Because the moment you do, you lose all perspective. Your enemy is not the lawyer questioning your witness. Your enemy is their argument. Your opponent is not the person filing motions against you. Your opponent is their case. And if you cannot distinguish between the advocate and the advocacy, you have already been outmaneuvered. The seasoned professional understands this. They treat their opponent with a detached, almost surgical respect. They know that the person on the other side is a necessary part of the process, a fellow officer of the court who has a job to do, just as they do. This isn't about being friends. It's about being effective. Let me paint you a picture I've seen 100 times. On one side, you have the bulldog. He's aggressive, he's loud. He interrupts his opponent constantly. When the other lawyer is speaking, the bulldog is shaking his head, sighing dramatically, rolling his eyes for the jury to see. He makes snide comments under his breath. In his mind, he's being tough. He thinks he's intimidating the other side, showing the jury he's a fighter. But what is the jury actually seeing? They see a child. They see someone who is unprofessional, disrespectful, and frankly unlikable. They see a bully. And nobody, absolutely nobody, roots for the bully. His constant interruptions don't make him look passionate, they make him look desperate, like he's afraid of what the other lawyer is about to say. Now, on the other side, you have the professional. She is calm, prepared, and unfailingly courteous. When the bulldog interrupts her, she doesn't bite back. She simply stops talking, turns to the judge, and waits. She lets the silence hang in the air, making the bulldog's rudeness the centerpiece of the entire courtroom. The judge, irritated, will inevitably say, "Counselor, let her finish." And just like that, the professional has used the bulldog's own aggression to win a point, score credibility with the judge, and paint her opponent as an amateur, all without saying a single word. When she speaks, she refers to her opponent as "my learned friend," or "counsel for the plaintiff." It's not fake politeness. It's a strategic tool. It's a constant, subtle reminder to everyone in the room, especially the jury, that we are the professionals here. We are engaged in a serious intellectual debate. My opponent, with all his theatrics, is not. This professional courtesy isn't just for show. It has profound strategic implications. First, it builds a bank of goodwill with the judge. Courtrooms run on a tight schedule. Judges have zero patience for lawyers who bicker over petty issues. The lawyer who is consistently professional, who can work with the other side to agree on undisputed facts, what we call stipulations, is a lawyer who makes the judge's life easier. And when a discretionary call has to be made, a 50-50 ruling that could go either way, who do you think the judge is going to lean towards? The courteous professional who saves the court time, or the bickering bulldog who wastes it? Second, it disarms your opponent and the witnesses. An aggressive lawyer expects aggression in return. When they are met with unshakable calm and politeness, it throws them off their game. They escalate, and as they do, they look more and more unreasonable. When the professional cross-examines a hostile witness, she doesn't raise her voice. She doesn't point her finger. She methodically, calmly, and politely corners them with logic and facts. The witness's lies become more frantic, their story more tangled, while the lawyer remains a picture of composure. The jury sees this contrast, and they trust the calm in the storm, not the storm itself. This leads to one of the most important unwritten rules of courtroom conduct. You address the court, not the counsel. If the other lawyer says something objectionable, you don't turn to them and say, "You can't say that." That's what you see in the movies. In a real courtroom, you stand up, you face the judge, and you say, "Objection, Your Honor." Hearsay. This simple act does two things. It shows respect for the judge's authority as the ultimate arbiter of the rules, and it prevents the trial from devolving into a shouting match between two lawyers. You are having a moderated debate, and the judge is the moderator. Directing your arguments, your objections, and your frustrations to the judge keeps the structure of the trial intact and reinforces your role as a disciplined professional. Another key is knowing which battles to fight. The bulldog fights over everything. He objects to the phrasing of every question. He argues over every piece of minor evidence. He is fighting a war on 100 fronts, and in doing so, he exhausts his own credibility. When he finally has a truly important objection to make, it gets lost in the noise of all his other frivolous complaints. The jury has tuned him out. The judge is already annoyed. The professional, however, chooses her battles with the precision of a sniper. She will let 10 minor, technically objectionable things slide. She knows they don't matter to the outcome of the case. This makes her look reasonable and confident. But when she does stand up, when she finally says, "Objection, Your Honor," the entire room freezes. The judge leans forward. The jury pays attention, because they know if she is objecting, it must be for a very, very good reason. By conceding the meaningless, she gives immense power to the meaningful. This is the hidden language of the courtroom. It's a world where courtesy is a weapon and respect is a shield. It's about understanding that the jury is not just listening to your words. They are watching your every move. They are assessing your character. Are you trustworthy? Are you reasonable? Are you the kind of person they would want to have on their side? Every sneer, every interruption, every act of disrespect towards your opponent is a point against you in that silent, crucial judgment. The best lawyers can be absolutely ruthless in their cross-examination and devastating in their closing arguments, all while maintaining a veneer of profound respect for the process and the people in it. They dismantle their opponent's case, piece by piece, and then when it's all over, they walk over, shake their hand, and say, "Good fight," because they know the war was never with the other lawyer. The war was for the minds of the jury, and it was won not with brute force, but with discipline, strategic, and unshakable professionalism. This discipline must extend to every single person you interact with in that courthouse, including the one person most new lawyers forget they are even performing for. That person is the court reporter, the silent, focused individual sitting near the witness stand, whose fingers fly across a steno machine at speeds that defy comprehension. You might think their job is just to type. You would be catastrophically wrong. The court reporter is not a stenographer. They are the guardian of the record. And in the world of litigation, the record is God. It is the Alpha and the Omega. It is the only thing that exists outside the four walls of that courtroom. When you appeal, the appellate judges don't see the witness's nervous twitch. They don't hear the tremor in your voice during a powerful closing. They don't feel the tension in the room. All they have is the cold, hard, black and white transcript. The record. The thing that court reporter is creating in real time from the chaos of human speech. And you, the brilliant lawyer, are making their job impossible. You're mumbling. You're talking too fast because you're nervous and over-caffeinated. You're talking over the witness. You and opposing counsel are shouting at each other like toddlers fighting over a toy. And in that cacophony, what happens? The court reporter, a human being, not a magical transcription robot, does their best. But maybe they miss a word. Maybe they can't distinguish who said what in the crosstalk. Maybe your brilliant, case-winning objection, "Objection, Your Honor, hearsay," comes out in the transcript as "Objection, you rear say," because you slurred it while your opponent was still talking. And when the appellate court reads that, they have no idea what happened. Your silver bullet objection, the one that should have won you the appeal, is gone. It vanished into thin air because you couldn't be bothered to speak clearly and show a little professional courtesy. Treat the court reporter like the vital professional they are. Before the proceedings start, go introduce yourself. If you have a witness with a difficult name, or you're going to be using a lot of technical jargon, write it down for them. It takes 10 seconds and makes you their hero for the day. During testimony, speak clearly. Enunciate. If a judge tells you to slow down, it's often because the court reporter has given them a subtle signal that you're auctioning off cattle instead of practicing law. And for the love of all that is holy, do not talk over other people. One person at a time. The record can only record one voice at a time. I once saw an appeal lost because the crucial admission from a witness was buried in the transcript. The lawyer had cut the witness off mid-sentence to ask another question, and the court reporter's transcript read, "Yes, I was the one who signed the..." The rest was an indecipherable mess of crosstalk. That single dash, that incomplete thought, cost the client millions. All because a lawyer was too impatient to let the witness finish a sentence. Your performance for the court reporter isn't about being liked. It's about protecting your client by creating a clean, accurate, and defensible record. This principle of strategic respect extends to every single employee in that building. Let's talk about the clerk of court. The clerk is the nervous system of the courthouse. They are not administrative assistants or paper pushers. They are the operational commanders who manage the flow of every case, every motion, every order. They know the judge's preferences, the local rules that aren't written down anywhere, and the precise magical incantation required to get a motion in front of the judge on an emergency basis. Getting on a clerk's bad side is one of the slowest and most painful forms of professional suicide you can commit. The arrogant lawyer who treats the clerk like a servant, who snaps their fingers and demands to know why their filing hasn't been processed yet, will find their life becomes mysteriously difficult. Their emergency motions will get filed at 4:59 p.m. on a Friday. Their phone calls will go to voicemail. Their questions will be met with a shrug and a suggestion to read the local rules. The clerk won't do anything unethical. They don't have to. They just have to follow the rules to the absolute letter with zero discretion and zero willingness to help. They can and will let you hang yourself with the rope of your own arrogance. Now, consider the professional lawyer. The one who learns the clerk's names. The one who says please and thank you. The one who, when they have a filing issue, approaches the counter and says, "Hi Mary, I know you're swamped, but I think I might have made a mistake on this filing. When you have a free moment, could you possibly point me in the right direction?" That lawyer is seen as a partner in the process, not an obstacle. That lawyer will get a quiet phone call. "Hey, just a heads up. Judge Smith is running an hour behind, so you don't have to rush." Or, "I noticed you forgot to attach Exhibit B to your motion. If you can get it to me in the next 10 minutes, I can add it before I give the stack to the judge." That is not special treatment. That is the grease of human decency that makes the gears of justice turn. The clerk of court can be a locked door or a golden key. The choice is entirely yours, and it is made long before you ever step into the courtroom. The same unwritten law applies to the bailiffs and court officers. These men and women are not just security. They are the judge's ears and hands in the courtroom. They see everything. They see you scrolling through ESPN on your phone during a boring bit of testimony. They see you roll your eyes at the judge's ruling. They see how you treat the janitor, the paralegal, and the opposing party's elderly client. And you can bet your bar license that they have a quiet relationship with the judge. The judge trusts them. When a bailiff mentions to the judge in chambers, "That lawyer, Mr. Jones, was really rude to the security guard on the way in this morning," it colors the judge's perception of you before you've even said, "Good morning, Your Honor." I saw it happen. A young hotshot lawyer was representing a tech startup. He was brilliant, but he carried himself with an air of immense self-importance. During a recess, the bailiff, an older gentleman who had been in that courthouse for 30 years, politely asked him to please take his phone call out in the hallway. The lawyer sneered and said, "I'll be done in a minute," and turned his back. The bailiff didn't argue. He just stood there stoically. 15 minutes later, court was back in session. The lawyer made a routine request for a 10-minute break later in the day to confer with his client. The judge, without looking up from his papers, said flatly, Mr. Smith, this court operates on a schedule of mutual respect. If you cannot be bothered to respect the officers of this court, you cannot expect this court to accommodate your schedule. Request denied. Call your next witness. The temperature in the room dropped 20 degrees. The lawyer's face went white. He had just been publicly humiliated, and his authority in front of his client was shattered. Why? Not because of a legal error but because of a character flaw. He failed to understand that in a courtroom there are no small roles. Everyone is watching. Your reputation is a currency, and you are either spending it or earning it with every single interaction, from the moment you park your car. The security guard who greets you at the door, the clerk you file a motion with, the janitor you pass in the hall, the opposing counsel you share an elevator with, the court reporter documenting your words, they are all part of the courthouse ecosystem. They talk. They form a collective impression of who you are. Are you the professional who is always prepared and treats everyone with dignity? Or are you the arrogant jerk who thinks the rules don't apply to them? Being a good lawyer isn't just about knowing the law. It's about being the kind of person that makes the system work, not the person the system has to work around. This foundation of respect, this professional discipline, is the bedrock upon which all successful courtroom advocacy is built. But of course, you can befriend every clerk, charm every bailiff, and perfectly enunciate for every court reporter. And it will all be for nothing if you fail to understand the complex, unwritten rules of communicating with the most powerful person in the room, the one person who holds your client's fate and your professional reputation in the palm of their hand. We are talking, of course, about the judge, the black-robed figure who is not merely an umpire, but the living embodiment of the law itself within those four walls. Every single interaction you have with the judge is a high-stakes performance, and the rules are absolute. First and most fundamentally, the form of address. It is Your Honor. Not judge, not sir, not ma'am. It is Your Honor. End of story. This is not a suggestion. It is a commandment. To use any other term is to broadcast your ignorance and your disrespect for the entire judicial system. A young, overconfident attorney in a Chicago courtroom once tried to build rapport by calling the judge by his last name, Judge Miller. During a sidebar, the courtroom went silent. The judge slowly took off his glasses, looked at the lawyer and said, "Counselor, there are two people in this world who call me Judge Miller. One is my wife and the other is my bailiff when he's telling me the courthouse is on fire. You are neither. You will address me as Your Honor, or you will be addressing me from a holding cell." Do you understand? That lawyer's credibility and his motion were incinerated in that moment. Your Honor is a shield. It maintains a necessary and respectful distance, reminding everyone in the room, including yourself, of the gravity of the proceedings. This respect is not just verbal, it is physical. You stand when the judge enters the room, you stand when the judge leaves the room, and you stand every single time you address the court. Every single time. Even if you're just saying, "Yes, Your Honor." Standing is a universal sign of respect and deference. It signals to the judge, the jury, and everyone present that you are giving your full attention to the court. When you rise, you are physically demonstrating that you recognize the court's authority. It's a small act that has a massive psychological impact. It shows you are engaged, you are serious, and you understand your place in the hierarchy of the courtroom. Sitting while speaking to the judge is the legal equivalent of mumbling. It's lazy, it's disrespectful, and it ensures the most important person in the room is not taking you seriously. Now, let's talk about one of the most misunderstood interactions, the objection. On television, it's a moment of high drama. A lawyer leaps to their feet, points a finger and bellows, "Objection!" In a real courtroom, that will get you reprimanded or worse, sanctioned. The art of the objection is one of finesse and precision, not volume. The procedure is a dance. First, you stand, promptly but without theatrics. Second, you state the basis for your objection in as few words as possible. Objection hearsay. Objection leading. Objection relevance. You are not making a speech. You are flagging a legal issue for the judge. Third, and this is the most critical part, you shut up. You have made your objection. The floor now belongs to the judge. They will either rule immediately, sustained or overruled, or they may ask opposing counsel for a response. Under no circumstances do you argue with the judge's ruling. If the judge says overruled, your only response is, "Yes, Your Honor," or "Thank you, Your Honor," and then you sit down. Your job in that moment was not necessarily to win the argument. Your job was to preserve the issue for a potential appeal. By objecting, You have made a record of your disagreement with the evidence. That is your victory. Arguing with the judge after they've ruled is like telling a referee he's wrong after he's already made the call. It will not change the outcome, but it will guarantee you a penalty. You will look petulant, unprofessional, and you will have poisoned the well with the one person you cannot afford to alienate. Sometimes, a matter needs to be discussed outside the hearing of the jury. This is when you must approach the bench. But you do not simply take a walk. You must ask for permission. From your table you stand and say, "Your Honor, may I approach the bench?" Or more commonly, "May we approach?" including the opposing counsel. If the judge grants permission, you walk directly to the side of the bench with the opposing counsel. You keep your voice low. This private conference or sidebar is a sanctum. It is where sensitive issues of law are debated. Breaking this protocol by, for instance, speaking loudly enough for the jury to hear, is a cardinal sin. It shows you cannot be trusted with the court's procedures and confidences. And never ever under any circumstances interrupt the judge. I cannot stress this enough. When the judge is speaking, you are listening. You are not thinking about your rebuttal. You are not waiting for a pause to jump in. You are absorbing their words as if they are gospel. The judge controls the flow of the entire proceeding. Interrupting them is a direct challenge to their authority. It's the ultimate act of disrespect. I saw a lawyer do this once, cutting the judge off mid-sentence to try and clarify a point. The judge's face hardened. He let the silence hang in the air for a full 10 seconds, which felt like an eternity. Then he said, "Counselor, in my courtroom I have the gavel. That means I have the floor. You will have your turn. Do you wish for that turn to be today?" The lawyer, utterly humiliated, could only whisper, "No, Your Honor." This leads to a more advanced skill, reading the judge. A great lawyer is also a great student of human behavior. You must be constantly observing the judge's demeanor. Are they leaning forward, engaged in your argument? Or are they leaning back, looking at the clock, tapping their pen? Are their questions pointed and curious? Or are they curt and dismissive? These are not random behaviors, they are signals. If a judge is showing signs of impatience with your line of questioning, it doesn't matter how brilliant you think your strategy is. It's time to move on. Pushing a point with a visibly annoyed judge is like trying to sell ice to a polar bear. You are wasting your time and, more importantly, their time. A lawyer who can adapt their strategy in real time based on the judge's cues demonstrates high emotional intelligence. It shows the judge that you respect their position and their time, which is the fastest way to earn their respect in return. And so we arrive at the end of our journey. From the shine on your shoes to the way you address the clerk, from your posture at the counsel table to your respectful silence when a judge speaks. Every rule, every piece of etiquette we have discussed, is a thread in a single magnificent tapestry. They are not arbitrary rules designed to make your life difficult. They are the language of the court. This language communicates far more than the words in your legal briefs. It communicates your respect for a system that is larger than any one person. It communicates your competence, your preparation, and your integrity. In a profession built on advocacy and adversarial conflict, courtroom etiquette is the code that prevents chaos. It is the framework that allows for the civilized resolution of disputes. It is the armor that protects the process and in turn protects you. Mastering this silent language is what separates a mere lawyer from a true counselor, an officer of the court. It is the difference between simply showing up and commanding a room. It won't guarantee you'll win every case, but it will guarantee that you are seen, you are heard, and you are respected. It builds a reputation that precedes you, a reputation for professionalism and excellence that becomes your most valuable asset. Because in the hallowed halls of justice, the arguments you make with your words are only half the battle. The other half is the argument you make with your character. And that argument begins the moment you walk through the courthouse doors.